And I'm going to say I'm turning the live feed back on, so the live feed's officially on. I know you all have people back at your offices watching, so I'm just saying that out loud. And James, if the jury is ready, then we're ready for them to come out. They can bring whatever drinks they want or whatnot. And I will say this worked. It cut our hour-and-a-half lunch down to 30 minutes. So, you know, maybe I should do this with every trial.
Remember, it's the you know what rule.
All right, everybody may be seated. Members of the jury, I hope everybody got to eat their fill. If you need anything else, just let the bailiffs know. Again, thank you for letting me feed y'all lunch and kind of bring the lunch in a little bit. We're trying to keep the case moving forward at full speed today. You'll remember you've already heard from the plaintiff's closing, and then the next is going to be Mr. Fletcher, Ms. Dabbs, and then Mr. Scholl will have the last say. I'll give you a few additional instructions, and then you'll have the phase 2 verdict in your hands to make your decision. Mr. Fletcher, the floor is yours.
Thank you, Your Honor. It's been a long, almost 2 weeks, so I'm going to try to be as brief as possible. I know y'all want to get back to your families and also make a decision in this case. We've asked you to sit patiently, to listen attentively, and to hear the evidence as it's presented. And just like the prior phase, the second phase still requires that, and we appreciate that. But for this damages phase, there's also the adherence to the law. You heard the charges that the judge gave you on the law, and for purposes of this case, you're only to stick within the confines of the law. That was your oath. And one of the key things that I have to address that is purely just lawyering by plaintiff's counsel was his description of actions as reckless conduct. This is not a case that's talked about recklessness. You have not heard one witness talk about recklessness. You have not heard one expert talk about recklessness. And in fact, you guys did not, if you wouldn't mind.
There we go.
Y'all did not find anything related to recklessness. The jury verdict form is written this way and says negligence. If this were a case about recklessness, you would have been charged on the law as to what amounts to recklessness, and the verdict form would have asked you to find if there's recklessness. But you appropriately kept your determinations within the bounds of the law on negligence. So whatever words that are going to be used by Mr. Scholl that are outside the bounds of the law, that's just lawyer speak. That's not to be considered. Now, I mentioned this in the opening, and it was based upon the verdict form. Y'all found that that Mr. Bennett's injury or injury was caused by the incident of July 1, 2020. But your verdict form did not indicate what injury it was. Our own expert, like I said, Dr. Frankel, he conceded, actually bolstering his credibility. Yeah, maybe there could be a muscle strain. And we have to explore that. And if that was what you decided back there as the injury to apportion fault to Mr. Evans and Transcontinental, we have to assume that factored in, and that was the reason, a strained neck. And if that is what you were determining back there, the damages for that we would submit are $50,000 to $100,000. That's normal for a strained neck injury. And while we disagree, we have to acknowledge the other conclusion he may have reached was that Mr. Bennett's central cord syndrome was caused by the incident of July 1, 2020. And if that is the case, and I'll come back to it, we would ask for a range of 650,000 to $1 million. And even the millions kind of deduct, you have to deduct from that what was the cost of the repairs to the truck and where that would have come from. But let's discuss how we get to that range. And there's only one hard number that has been put out to y'all that's basically not been disputed. $480,000. Those are the medical bills. That is what was the services and the care that was provided for Mr. Bennett, which made up all those medical bills in the summary you saw in their exhibit. Much of those medical bills were the 3 surgeries to his neck. Carolina's, when he did it at Carolina Health, and then 2 with Dr. Bendix. There's been no testimony that he was due for another one, and what is the cost of that. So the majority of the medical care has already happened. That is the hard number we know for the economic damages. Where we have issues of made-up numbers, conjured numbers, are from high-priced experts who base their numbers on pure speculation or improper hearsay. Let's focus on the life care plan. Mr. McCord got up and testified that he developed this whole life care plan, put these numbers, researched the numbers, what would be necessary for his care, what would be necessary for him to take care of him if he had to do things around the house or not do things around the house. But that's based upon the human condition of Mr. Bennett. And Mr. McCord merely said, oh, I got Dr. Figa to sign it. Well, what did Dr. Figa do in his methodology to come up with the treatment recommendations? Why didn't plaintiffs bring Dr. Figa? Why didn't they give the defendants an opportunity to cross-examine Dr. Figa? And you heard in the jury charges, if a party fails to produce an available witness, the jury shall determine whether such a failure warrants the inference that the witness, if produced, would have testified to facts prejudicial to the party failing to produce the witness. Prejudicial to the party that failed to produce the witness. So we have to ask ourselves, why was Dr. Figa not here? Would he have said, no, that's totally wrong, the life care plan. It's much less. Or no, we don't even need it. There wasn't even a doctor to come in and say that that life care plan was appropriately created for the injuries that Mr. Bennett claims he suffered in the incident. And that is key. So, life care plan. You don't have to accept what these high-priced experts said. You guys probably questioned our own experts. Because ultimately, the decision rests with you. The experts aren't saying what is incontrovertible fact. They're just, this is what we think because we have the background. But it's y'all that get to decide what's the amount. Now we turn to the economist. Mr. Gingras. It's pure speculation. He didn't even put in the effort to ask for the tax returns. The one thing he admitted was the most important document that would show what Mr. Bennett made over a year or 2 years. And an economist such as Mr. Gingras wouldn't even have to go through 5 or 6 years. He could take the last 2 or 3 and have a much better idea of what Mr. Bennett was making. We can all go get our tax returns. It's an easy request to the IRS. You lose one, you have to provide it to someone, you can get it, order it, comes right in. Why was that not produced? It's not a clerical error. It's not a, oops, I forgot. If you are going to listen to Mr. Scholl say a medical card was fake, we don't have a tax return, I would submit to you it's because no taxes were ever filed. So without the tax returns, without the W-2s, without so much even a mileage or trip sheet to indicate the type of miles Mr. Bennett was driving over the years, Mr. Gingrich just says, well, I'm going to assume he worked every day, and he was diligent. He showed up, every employer, 16 of them over 4 years, over 23, over 10 or 12 years. And why aren't those mileage reports even shown? Would it show that he drove out of the way to gin up his miles from Brunswick to Wilmington? Is that why they're not produced? We don't know. So instead of getting hard numbers, we get an expert who just says, hey, his lost wages and lost benefits are this because I say it's so. You must believe me. That's just based upon assumptions. Oh, and these life tables, I relied upon these things. They're trustworthy. You get to make the decision as to whether they're trustworthy, not Mr. Gingrich. So again, what's that amount? It's not a hard number. Now, we get to the non-economic damages, pain and suffering. And yes, that's up to y'all. What is pain and suffering? The judge read the charge on pain and suffering, and I'm not going to read it again. It's just otherwise. It's up to you. You can take the numbers up on the board, or you can dismiss them. And when I say the board, I mean the presentation of what plaintiff's counsel put up there and their numbers of what pain and suffering number you should put out there. But sometimes it goes too far. You're allowed to dismiss that. And so when I put up the 480, and let me scoot down here. We have this hard number. But pain and suffering, life care plan, and the economist, that's the difference. If you find, or if you believe, that this incident caused Mr. Bennett's central cord syndrome, double the medicals. It's a significant sum. It gets you to that amount of $1 million. And even if you want to discount the life care plan and the economist, that is a good number and a significant number to get to the million for just pain and suffering. So, ladies and gentlemen of the jury, I hope, again, that we've done right by Mr. Ogletree, and we put up the appropriate defense, laid down the appropriate facts, put up the appropriate witnesses, and then helped you by pointing out the inconsistencies in those witnesses. We believe that the appropriate verdict range is between, 650 and 100,000. But double the 480 to 1 million, and you've got an appropriate verdict. So thank you so much for your time. And actually, before I conclude, let me just see if I've got any more input. I'm finished. Thank you so much for your time. Ms. Dabbs has the opportunity to speak and maybe fill in some gaps that I left out. And so just as well as you paid attention to me, I hope you would give her the same attention because we've all done a fabulous job these 2 weeks. Let's just see this across the finish line. Thank you so much.
Thank you, Mr. Fletcher. Ms. Dabbs, would you like to make a closing argument?
Yes, sir.
The floor is yours.
I'll be as brief as possible, I promise. I'm not going to add Mr. Fletcher's argument, but I do just want to thank you for your time, your attention.
All right. Final close?
You ready for it? Ladies and gentlemen, I just want to address a few points. The recklessness is not lawyer speak. That's actually in your instructions. I want to show you the instructions you got in the case.
She's waiting on me. Hold on.
Okay.
I think you're waiting on. Yeah.
All right, it's up.
Your Honor. Maybe.
You may. For the jury, as you'll remember, I've got just a little bit more here to give you, and then you'll have this case for deliberations on phase 2. Members of the jury, you're about to go into the jury room, and I have a few final items of housekeeping. Number one, as I said in phase 1, there will always be a bailiff outside the jury room during your deliberations. If you have any questions for the court, please write out your questions in the same way. Have your foreperson sign the question, knock on the door. The bailiff will be there to respond. Fold the paper for privacy. Hand the written question to the bailiff and resume your deliberations. The bailiff will bring the question to me while you continue deliberations. Once I have your question, I will respond in writing, which will be delivered by the bailiff to you, or I will call you out into the courtroom to address your question. Once you have a verdict, you'll follow the same procedures, except your foreperson will keep the signed and dated verdict form, and your foreperson will actually bring it into the courtroom when called. I will then ask your foreperson the same questions I asked in phase 1, and obviously, as always, just keep the seat that you're in. Mr. Before you begin your deliberations, again, please turn off your cell phones, hand them over to the bailiffs when you get back there. We'll just do it in a second, Margaret. And then the bailiffs, of course, will keep them secure. As before, I resumed responsibility for our schedule. As long as y'all are in deliberation mode, you are in charge of our schedule. So you all will decide during your deliberations, and I will follow whatever directions you provide regarding our schedule from this moment forward until you've delivered your verdict here in phase 2 regarding damages. I have an example here that says if you want to order food, you can do that. If you're still hungry, I think there's food still back in your jury room. Whatever your deliberations are, the court is here to support you. Again, please do not begin your deliberations until these instructions have been followed. The bailiffs will deliver to you the exhibits from both phase 1 and phase 2, so you'll have all the exhibits back there, this verdict form, and these instructions once you have all of those. Alternate jurors, you all know who you are, so if you will please gather your items and then come back to the jury box, and I'll give you all some additional instructions as soon as you've come back out and had a seat in the jury box. Anyone have any questions before we step into this? Okay. Then that's it. You all may step back into the jury room. Grab your phones from wherever they are. Margaret will take them from you. And I will see the alternates back in the jury box in just a second. Margaret, here's the charges. Okay, so let's just, y'all can sit or stand as you prefer. The question on the table is, we have phase 1 exhibits, phase 2's exhibits, but they're just trial exhibits. And I said that they were going to get all of them. Is there any issue with them getting all of the exhibits?
No, not from plaintiffs, sorry.
Well, excluding those that we made continuing objections.
Let me rephrase that. You're right. That was inarticulately worded, and Mr. Fletcher appropriately called me on it. Do you have any objection with them having the exhibits that they had in making their decision in phase 1 in the jury room with them during phase 2?
Yeah, I think we object. I think because it's broken up into phases with openings and closings and admissions, it should be just the evidence that's submitted for that phase.
Your Honor, the medical records were submitted in phase 1, and the medical records are relevant to the extent of injuries.
Yeah, I get it.
But we do have an exhibit with all the medical bills and the summary going back into the jury deliberations potentially
for this phase. And the statute's very clear that these are two separate phases that are adjudicated separately, independent of each other.
This is damages, Your Honor, not causation.
Okay. All right, anybody else? And of course, there's also still the continuing witness objection that's still standing. Anybody else need access to the record while I sit here for a minute and sort that out in my head? Because I want to get the exhibits back there in some form or fashion as soon as possible. Anything else?
Well, just on this point, I think that she's right that it does say keep them separate. There may be some relevant exhibits like Mr. Bennett's his medical records may be relevant, whereas the defendant's medical records are not relevant. So I think that we should probably think about that issue of the exhibits.
I mean, this is the thing, we're all just to say this out loud, this is a brand new issue in Georgia that we're all working through. I've said it before and I'm gonna say it again. I am very lucky to have you all looking back at me as we are figuring this out. It's a privilege being in here with y'all. This is why I said it in the charges that they're gonna have them, and then I had a moment where I'm like, should they? Some of them are kind of important, but not all of them. So, how about this? What if Mr. Bennett's medical records went out? I don't remember what those numbers are, but I know we have them all. Would defense object to Mr. Bennett's medical records going out in conjunction with the summary?
We would object, Your Honor.
You would?
We would object, Your Honor. I mean, it's a hard line. And everything that's everything that's within phase one, there's the hard line, and then phase two. So what's admitted in phase two, that should go back.
Okay.
And I mean, frankly, Your Honor, if that was, the medical records were something that needed to be relied upon in this phase, that could have also been introduced during this phase as well. So Mr. Bennett testified twice separately to each issue. We could have done that then. We didn't.
Okay. All right. Anything else before we go off record and I kind of try to parse this out just a minute? All right.
Yes, Your Honor, just briefly. Both parties throughout phase two have referenced Mr. Bennett's medical history, records, treatment. It's been referenced in both opening statements and closing statements of both parties. I believe you're correct in that any liability specific related exhibits should not go out. But this is phase two of the same trial. This is not a second trial. There's nothing in the statute that contemplates entering the same exhibits 2 times in the same trial. Just as in a punitive damages phase, exhibits from the initial phase for compensatory damage can still be provided to the jury and referenced in the punitive damages phase of the trial as well.
All right. Let me just put on the record before Mr. Fletcher jumps back up that, and I told y'all this off record over the lunch break, that I've reached out to the other state court judges. Frankly, I've been speaking with them throughout this, trying to make certain that y'all get their combined wisdom instead of just Josh's. But what I realize is that we're the 4th trial out in the state court system that we're aware of, but we are the first one that's made it to phase 2. All the 3 other trials ended at the end of phase 1. One was a mistrial, one was a plaintiff's verdict that settled, and one was a defense verdict that closed the case. So we're the first ones out. So I'm just saying this out loud that there's no guidance. I have no rules. We are figuring this out as we go. Anyone else need additional access to the record? I think it was your turn, Mr. Fletcher.
Yeah, I'll just be brief. The issue of his medical condition was really posed to the jury because they had not, on the verdict form, indicated which type of injury they were finding for plaintiff on. That was the only reason. But otherwise, we defer to Your Honor. We would just ask that only the phase 2 exhibits go back.
Okay. Ms. Stabbs, anything else?
Yeah, I'll just add quickly that what the defense is asking for here is consistent with how this court has decided how these 2 phases should be tried previously. We kind of all, or frankly, Your Honor, came to the conclusion that the second phase was going to be about dollars and cents for the most part. So we're submitting that to the jury.
That is correct. Then All right. Anything else?
Your Honor, just out of an abundance of caution, I mean, I don't think it's gonna be a big deal to them. I think they could ask, if they wanted to see a record, they could ask for it, we could deal with it at that time.
Oh, I really like that idea.
Yeah.
Because then we could have a conversation about what goes back. Even if y'all disagree with it, we would at least be very intentional. All right, let me think about this just for a minute. So y'all give me just a few minutes, and then y'all go ahead and look at what's here for phase two. And then I'm going to give you the continuing witness ruling as well.
When you guys are done, I'd just like to hear.
Yeah, I mean, you come over.
I did research continuing witness over lunch. The rule requires that it be read to the jury. There were, how many pages was the report, the economist report? And I'll say out loud that I think it said like 2-point font, because I tried to read it, and I need both glasses and a magnifying glass.
I think it's 28.
Okay, so I'm going to find that the 28 pages were not read to the jury, and so part of it would not be continuing. So I'm going to let it go out and make certain that y'all's objection is clear for the record, that it stands. And that I'll go and say, I think it's a reasonable question that I couldn't find a concise answer to, which is what if an item was only partially read into the record? Everything I found was like a witness statement read in. So I want to make sure y'all have plenty of access to the record on that.
Yeah, thank you, Your Honor. I just want to clarify that I believe Mr. Gingas read the most important parts as he was going through it. The 26 odd pages, that's just the random numbers for the Excel spreadsheet tabulation.
I agree with
I
everything
don't
you
know
just
how
said.
even reading in column 1, row A says 4.
I could not agree with you more. I just was going off the rule that said it must be read into the record from the witness stand. So again, I look forward to seeing what the Court of Appeals says on that one. I'm going to go with the compromise position on the phase one exhibits, which is I'm going to ask Margaret when she leans in to say these words to them, which is that judge says, if you wish to have any exhibits from phase one, you may request them. They'll stay out here, and then they'll have those instructions, which y'all will still object to, but I would feel better about.
Yeah, I just want to state for the record that we didn't agree to the compromise, but whatever the judge decides, we'll adhere to it, and we'll pose our objections where necessary.
Okay, that's fair enough. Because again, these things need to go, and I don't, my nightmare, let me just put this clear on the record. My nightmare scenario is these issues which need clarification from the Court of Appeals, because I've not done the right check boxes. The Court of Appeals says something is waived. So I'm trying to be really careful because I want these things to be preserved so that we can get the clarity we need moving forward. So that's just very important to me. All right, anything else, housekeeping from the plaintiff?
No, Your Honor.
Defense?
No, Your Honor.
No, Your Honor.
All right, Margaret, if you'll please tell the jury that Judge Thacker says if they wish for any exhibits from phase one,
That's
they may request them. So if they want, and you can say it however you want, but it just needs to be, if they want any exhibits from phase one, they can request them.
No, those don't go. And Your Honor, just, I want to make sure, like we did in phase one, make sure we know exactly what exhibits were entered. I don't think we did that in phase two.
Okay, let's, Margaret, come on back. No, that's right. All right, y'all, let's come back on record. Mr. Myers wants to do a confirmation that we have the correct exhibits going out. What do you have?
I have 45 admitted, but continuing witness, that was the day in the life video.
Yes.
I have 46A as the unredacted medical records that were just sent electronically. Those are not going back. 46B, the medical billing summary, is going back. Those redacted ones. I have Mr. McCord's CV, Exhibit 61, admitted, but continuing witness not going back, and his life care plan 62 admitted, but again, continuing witness not going back. And then I have Mr. Gagus's report, plaintiff 66, admitted and going back over continuing witness rule objection from the defense.
Say that one more. What was the last one?
Exhibit 66, Mr. Gagus's report, admitted and going back over their continuing witness objection.
That's what I want to make certain that was clear, that it's going back over the objection of the joint objection of the defendants.
Yes, sir, and I believe that's the last phase two specific exhibit.
Okay. All right. With the defendant's objections standing, the bailiffs may take those back and again, give them instructions. Again, it's just anything in the ballpark of, you say to them, if you want any exhibits from phase one, just send out a request. All right. Any objections to the charges as I gave from the plaintiff?
Your Honor, we object to the nominal damages instruction.
Okay.
I think that's it.
All right. Any objections from the defense?
No, Your Honor.
All right. Then the charges stand as they are. Exceptions noted. All the ejections are preserved. And again, I am very lucky to have such high-quality attorneys working as a wonderful team of adversaries
Thank you.
to help us figure out this new rule. And so very lucky to have you all. And again, I'm taking lots of notes and I'll be passing these out to the judges. So you'll very likely see these forms again in other courts.
Sure.
So, all right. Thank you all very much. We're off record until the jury sends a question or a verdict. Unless anybody needs anything else.
Off the record.
Okay. And Mr. Fletcher asked access to the record, so here we go. Floor is yours.
Yes, thank you, Your Honor. And of course, my computer shuts off and it'll take longer for me to revote. But at this point, on behalf of defendants, I'd like to move to dismiss plaintiff's claim OCGA 13611. We have heard testimony and evidence from both phase 1 and phase 2. There is no evidence of stubborn litigiousness. There is no evidence of causing unnecessary trouble and expense. And now let's turn to the main one, acted in bad faith. There is no evidence of either any conduct rising to a level above negligence. We had the jury just enter in phase 1 a finding of negligence. So the fact finder has spoken on that issue. But getting to the most recent case that came out a couple months ago, Love versus McKnight, it was in our jury charge, and of course, my computer just logged me out.
I'll have it here in a second.
It's in the back of our special jury charge as a citation. The court found that mere violations of a regulation or statute does not form any basis for bad faith to support an award for attorney's fees. And we have a bona fide controversy here. The evidence has shown and presented, we've shown the jury evidence and testimony, both non-experts and experts, as to what could or could not have caused the injuries to Mr. Bennett. So at this basis, without any evidence to support, at the very least, an indication of bad faith, we would ask the court dismiss plaintiff's claim for attorney's fees under OCGA 13611, and the case site is Love v. McKnight, 913 Southeastern 2nd, 614, obviously Georgia Supreme Court 2025. We don't even have the Georgia recorder citation, it's so new. But there's also the Metro Marta versus Mitchell 289 Georgia App 1 in 2007. According, just a summary of those cases, bad faith imports a dishonest purpose or some moral obliquity and implies conscious doing of wrong and means a breach of a known duty through some motive of interest or ill will. All of our ears have heard the testimony evidence today, and there's nothing that supports that. So we'd ask the court to dismiss plaintiff's claim for attorney's fees.
All right, Ms. Dabbs, do you wish to add anything else before I pivot to plaintiff?
I do not, I echo that sentiment.
Okay.
Your Honor, Mr. Evans, the defendant, misrepresented his medical status. He lied on his federal forms about his insulin dependence. He drove, or he was certified under false facts. He was qualified by the defendants who didn't know the rules on diabetic drivers, didn't know the rules on insulin dependent drivers, and were intentionally ignorant about that. He drove, he did not take his insulin. There's evidence he had an insulin monitor that he could wear on his arm that would not, you cannot turn it off. It would ring to his phone all the time. He knows what he's supposed to do with the insulin. He did not take his insulin and was not even supposed to be out on the road. So there was dishonesty there. But for that dishonesty, he wouldn't have been on the road. But for the defendant's recklessness and not knowing the rules, the corporate defendants, he would not have been on the road. So there is evidence. They made this motion for summary judgment, Your Honor, and it was denied rightfully. And that case was out. They cited that case in their brief. We cited the cases in our brief, and the court rightfully denied the motion.
Okay. Do you still wish to hold on to, sorry, my brain is
The two other reasons for it?
Yes. Do you still want to hold on to to 2 and 3?
Stubborn litigiousness and
Unnecessary trouble.
Yes.
I'd like, those are the three elements of the statute.
Yeah, but it's or, so it's one.
No, and that's what I mean.
Yeah,
He's
okay.
asking
Yeah.
you which ones you guys want
Yeah,
to
so we pled.
stipulate to.
Okay.
So
Maybe
that-
1 second, Your Honor.
Yeah, let's let y'all
Yeah.
talk off record, because
Well, while they're talking about that, mind if I just respond?
not at all.
Yeah, Your Honor, obviously at the summary judgment phase, that is before you actually hear all the evidence that's presented and before you have a fact finder and you determined that there was enough genuine issues of material fact at that time to allow their claim to stand. But now hearing the evidence and hearing the testimony that was presented, I would posit to you, Your Honor, that you have enough information to determine if there is enough information to even remotely support a claim for bad faith underlying the statute 13611. And I encourage Your Honor at the break to review Love versus McKnight, because the Supreme Court talks about such the heightened level of conduct, almost arising to punitive damage type standards. And not only is there no evidence of that, there's no judgment by the fact finder of such conduct. They have found that there's only negligence. They have not found gross negligence. They have not found conscious indifference to consequences. So they have already determined that goes to the basic of mere negligence. And this argument that they have presented evidence about lying about a condition or intentional blindness, there's no evidence of that. That's just their own lawyer conclusion. There is nothing with respect to Mr. Evans where he said, yeah, I know I'm supposed to take it, but I'm not going to take it. There's no smoking gun or intentional blindness to the regulations. That's counsel's own conclusion. There's nothing indicating that hard evidence that Brandon Ogletree knew the regulations but said, oh, I don't care. He testified he didn't know. And the expert testified what was required. So there's no evidence at this point that rises to the level of bad faith as justified under the statute or Love versus McKnight.
Okay, thank you. Mr. Schultz?
Yeah, Your Honor, conscious indifference to the consequence is the punitive standard, and that is one step below 13611 attorney's fee standard. Conscious indifference to the consequences is what I would argue in this case. Mr. Evans knew that he's required to know the rules. The carrier's required to know the rules. The driver's required to know the rules. He knew the rules. He was going to an endocrinologist at the same time, getting prescribed insulin, and then going to a chiropractor. He didn't go back to the endocrinologist to try to get certified. He went to a different chiropractor who's not qualified to treat diabetes, and told the chiropractor he was not on insulin. And then he turned around and drove, didn't take his medicine for 2 days, and basically caused a lot of mayhem on 75. Now, if that's not he consciously knows the consequences. He knows in his records, it's very clear that the doctors warn him about ketoacidosis. They warn him about the risks. Mr. Isaac said these patients are educated. Candy Nobles James, who they didn't play, also says that he was educated on driving and the dangers of driving. He's acknowledged that he knows how to be in compliance. He's acknowledges he knows when his insulin's getting high. So that's all in the record. And the jury could find through that record that he was consciously indifferent, which is the standard for punitive, which more than meets the standard for attorney's fees. And as to the question of, well, the jury was never given that. Why didn't the jury find gross negligence or recklessness or whatever? They weren't posed that question. They're going to be posed that question in this attorney's fees trial.
All right, so let's pivot back to my question from a few minutes ago, Mr. Scholl, which is that, are you still requesting to be able to move forward on being been stubbornly litigious, sorry, Terry, and caused unnecessary trouble and expense? Are you trying to hold on to those two as well?
I don't think so, Your Honor. I have counsel upstairs, but I don't think we're proceeding on those grounds. And so I'd like to, but before I commit to that, I'd like to just go talk to her. But I think that, no, we're not proceeding on those grounds. It would just be bad faith in the transaction.
All right, and then bad faith, I gave you all a definition that I liked out of the federal court system, but frankly, love has a better definition. And so when you all look at what I sent out yesterday, which are lines 114 through 118, then
I did see that, Your Honor.
yeah, that's going away because love is a better definition. Love says on page 617 of the Southeastern Reporter, it says, transactions that will support a claim for bad faith expenses of litigation in a tort action requires conduct that is generally indicative of intentional wrongdoing or of a reckless disregard for known harmful consequences and must be more than mere negligence. That's just I'm just simply saying, if I do go forward on the bad faith, that's a much more concise, clear, and frankly, Georgia-centered definition.
And with the judgment in phase one by the jury, I don't see how you can go past that. I mean, you're asking them to reevaluate all the liability decisions they made in phase one.
Yes.
If there was conscious indifference to consequences, he would have had a punitive damages claim. If it was grossly negligent, or if he wanted something on the verdict form for the jury to find that's in excess of mere negligence, he could have argued for it in the jury form. The fact finder has spoken. It's mere negligence. So therefore, a 13-611 under bad faith is null and void.
Okay, I hear you, but I've got to finish the questions I had. So I have a second part of this question. The jury apportioned responsibilities in phase one of, I believe it was, y'all have it, 70-30.
70-30.
70-30. Okay, so 70 Transcontinental, 30 Evans. Assume just for the moment that I'm moving forward, I'm going to allow it to move forward only on the bad faith. Is this a different apportionment, or does that matter? Am I overthinking this?
It doesn't matter to plaintiff, Your Honor, and I think that the new statute contemplates that they portion in phase one, and that applies to damages. I know in phase two, it would seem to me that it would apply as well in the third phase.
Okay, my plan is to allow that apportionment to carry to carry unless someone comes up with a better idea that could be implemented without 14 professors from Emory to tell us how to do it.
We don't care. I'll let them talk about it.
So without waiving your objection, so let's be really clear. I am not asking you to waive your objection. I'm asking you to kind of theorize with me for a minute that I'm putting bad faith on the table. I'm taking the other two out. Does the apportionment that was assigned in phase one, is that acceptable, or would there need to be a new apportionment?
Frankly, Your Honor, that bakes my noodle to think
well,
about.
that's-
I don't even know the answer to that. I think, give me a second to process this.
Well, that's fine. Again,
I don't think, and I reserve the right, obviously we object ultimately to the 13-611, so I think that protects us.
yes.
I think there would not need to be another apportionment. I think the fault is the fault, which goes to the underlying bad faith or alleged bad faith.
Yes.
But then if you see that to the next logical conclusion is what type of fault did they find, which was just mere negligence.
Yes.
So I think you don't have to find an apportionment again, but in cases like these, it's still probably coming from the same pot.
That's right. And let me just say very clearly on the record still that I was not asking you to waive your objection. I was asking you to do
Understood.
I know. I just want to make sure you're protected. That I just was asking you to do a thought exercise because again, attorney's fees are not new, but attorney's fees after a phase two
And phase one.
and a phase one are new. It's an old thing and a new spell. So, okay, you go talk to whoever it is.
Sure.
I guess it's your expert. So,
Yeah.
but
But we anticipate it'll just be bad faith. that helps you.
Okay, it does help tremendously. Let me think about that request, the question on bad faith. Let's go off record, unless anybody needs anything else.
No, you're not.
Okay, so I'm gonna chew on that bad faith question. I'll be back in just a bit. Go back on record. So the jury's not said they have a verdict as to phase two. So we'll bring jury out, same process as last time. I mean, I guess they could elect a new foreperson for each one, but I assume Mr. Stewart will still be our foreperson. I'll ask him the same questions, confirm it's appropriate, pull it up, make certain it's in the right form, and then I'll read it out, have y'all come up, take a look at it, give me your objections as to form, if any. If y'all wish for me to poll or anything else, go ahead and let me know. So as far as what happens after that, I've been thinking about it, and I think that for directed verdict purposes, I think there is some evidence that I think if the plaintiff had opposed, golly, my brain is not doing what I want it to do.
I'm tired too.
So, if plaintiff had opposed 2 and 3, I would have still left bad faith and I would have still taken 2 and 3 off because I do believe there's a legitimate issue in this case needed to be tried. And I think y'all have done a great job with it. But I do think there is some evidence, any evidence, that there may be some bad faith. Now, the jury may not see that, and I'm not saying there is. I'm just saying it could be interpreted that way. And so this is an any evidence standard. So, Mr. Ogletree, I just wanted to say that very carefully. I'm not at all saying that I'm finding there's bad faith. I'm just simply saying there's arguably something there. So I just wanted to be very careful about that. So you heard me say that I'm not finding something's there. I'm just finding it's arguable. So that's the only thing that will be here for the attorney's fees. Anything else before, are y'all ready if they, to move into the next phase?
We'd like 15 minutes, Your Honor.
I can do that. That's no problem. So,
And I do would like, I'd like some pre-argument before he puts up his first witness too.
okay, we can do that during the 15 minutes. That'll be fine. So, all right, perfect. Well, plaintiff ready for me to bring jury in?
Yes, Your Honor.
Okay,
Yes, Your Honor.
all right,
Yes, Your Honor.
all right. If the jury's ready, they may come on out. All right, and if you'll, Margaret, if you'll grab our two alternates. They literally just sat down, y'all, so they're only 10 seconds ahead of you. Okay, you ready? All right, if you'll stand up for me. Again, state your full name.
Jordan Stewart.
Mr. Stewart, has the jury reached a verdict?
Yes, sir.
And as to phase 2 damages, is it unanimous?
Yes, sir.
And have you recorded that verdict on the verdict form I provided?
Yes, sir.
With ink, not pencil? Okay, if you'll pass it over to Margaret. And you may have a seat. All right, I find that it is in proper form. It reads, "We, the jury, award damages to the plaintiff in the amount of $7 million." Y'all come up and take a look at it.
Yes, Your Honor.
Thank you, Your Honor.
All right, any objection to the form of the verdict, Mr. Scholl?
No, Your Honor.
Fletcher?
No, Your Honor.
No, Your Honor.
All right. All right, so members of the jury, that, don't kill me, there's one more phase. Each phase is faster, and this is the last phase. So remember me, I said these, again, the Georgia legislature changed this around, I'm so sorry, but each phase goes exponentially faster than the last. You've noticed that. This one is going to go so fast that I think we can finish today. So, so don't lose all hope. I think we're going to try to give this a shot and finish it today. This is the last phase. I was not allowed to tell you that earlier. And so this last phase is what's called attorney's fees and expensive litigation. So phase one was fault, phase two is damages. This phase is the shortest. What I'm going to do is I'm going to give them a couple of minutes to get their notes ready. And then we're going to jump right in. And my goal is for us to finish today. I just want to let you all know how much we genuinely appreciate the patience y'all have had for us. I know this is frustrating. If it makes you feel any better, I'm not totally in love with the phased system, but my opinion on the matter is irrelevant. Because obviously I'm looking at your faces as I'm telling you. And by the way, this is not y'all, but there is a scenario that the judges mapped out where you could have 4 or 5 phases. So, not that that makes y'all's life awesome, but we're going to get this finished. So if you all will step back in the jury room, don't do any homework, give us just about 10 minutes or so, maybe 15 to get reset, and we are going to try to finish today, okay? All right. And Margaret, will you grab the jury charges and let me get those stamped in? Almost done. Perfect. Okay, any exceptions or objections to how I've received the verdict?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right, then we're going to do a 10, 15-minute recess. Y'all let me know as soon as you're ready.
Will we then go back on the record to do some argument before?
We can go and do it now if everybody's
Might
ready.
as well get out of the way.
Yeah.
Let me just.
Can they have the phone?
Yes, you can give them the front page. Go ahead.
Yeah, Your Honor, now that we're at phase 3, we anticipate plaintiff's going to put up an expert as they disclosed, but as one of their exhibits is an Excel spreadsheet that's going to be asking for multipliers, which I believe are multipliers based upon the terms of the contingency fee agreement Mr. Scholl has with Mr. Bennett. I think, well, one, the contingency fee agreement, if it's put up as an exhibit or demonstrative or whatever, is so prejudicial in light of the new statute that it shouldn't even be referred upon. And then the multipliers, how is he going to explain how this multiplier, which is clearly based upon a percentage of recovery under the contingency fee agreement, so we,
All right.
so we argue, and Ms. Dabbs wants to get up here and do more of the legal argument. I'm just setting it up. That the contingency fee agreement, it's kind of an end around the statute to talk about a multiplier in his request for attorney's fees. And where does he get that multiplier from? The contingency fee agreement. And I'll have Ms. Dabbs argue more of the law on it. I'm just the setup man for the purpose of the day.
All right, Ms. Dabbs, the floor is yours.
Thank you, Your Honor. All right, so in light of the new statute, and I'll read the language, it's line 134 through 137, subsection B of section 4. Oh, I'm sorry.
Yeah, it's just
That was
not
my
on.
fault. Can you hear me now? Yes.
All right, that's better.
Should have had a louder voice. In any civil action, if a party seeks to recover attorney's fees pursuant to any statute authorizing an award of reasonable attorney's fees, a contingent fee agreement between such parties and such parties' attorney shall not be admissible as proof of the reasonableness of the fees. Plaintiff's counsel is making a request for attorney's fees under 13611, which allows for the expenses of litigation. Under statute 91516, however, states that any award of attorney's fees is based on the reasonableness of such fees. Georgia law is pretty clear that 13611 is a compensatory statute. We don't particularly see a need to put the contingency fee agreement in. One of the exhibits that they've proposed is a list of their expenses of litigation and the time and the cost that they've spent in this litigation, absent any mention of a contingency fee. Yeah, so
we think that in light of the new statute and the plain language, there shouldn't be any admissibility of that contingency fee agreement when there's a breakdown of the actual costs of the litigation. I'm assuming there'll be an argument that this is directed to the 9/11/68 award for attorney's fees, which is based in reasonableness. But again, any award for reasonableness or any award for attorney's fees in Georgia is based on the reasonableness of such fees. And if that were the legislative intent to only apply to that one section of an award of attorney fees, that would have been enumerated in that section of the new bill. So we think that the statute is pretty clear that the contingency fee agreement should not be admitted as evidence. So we would like to ask that that be excluded.
Okay, Mr. Scholl?
Mr. Myers.
Mr. Myers?
Yes, Your Honor. I don't think any of the exhibits we've shared with defense were the contingency fee agreement. We have no intention to put the contingency fee agreement into evidence at all. We've done an estimation of our time records. We've had Ms. Childers review them. We've had Ms. Childers review our firm's file and records. She's going to testify about the hours, the reasonableness, and the standard fee for these types of cases in the industry, but she's not going to talk about plaintiff's contract with Mr. Bennett at all. About Ms. Bennett, and the multiplier that she references, just to give you a preview, is with regard to going to be about her testimony about the difficulty in the cases and what's been authorized in other cases, which are also cited in that exhibit yourself, if you'd like to put the case law there.
What's that case, what's that exhibit number?
It's 146 that I emailed this morning.
And bringing up, oh, sorry, Your Honor.
No, I'm saying, go ahead.
Well, bringing up those cited cases, those are all referencing the introduction of contingency fee agreement and the 40% contingency fee, whatever, for the reasonableness of attorney's fees in order to show that multiplier. So the statute doesn't say a written contingency fee agreement is excluded. It says a contingency fee agreement. The multiplier is clearly based on the case law allowing a contingency fee to result in that multiplier in the reasonableness. Plaintiffs wouldn't have cited those three cases. I can give you the citations of the cases if you'd like.
I'm ready.
Versus Georgia Department of Corrections, 25 GA 469.
I typed it in wrong. Give me just a second.
Okay. My handwriting could have been off too.
All right, try again.
So Georgia Department of Corrections, 2295 GA 469. That's number one.
Okay.
Number two is Taylor versus Devereaux. That's 316 GA 44.
Okay.
And number three is Cajun Construction. That's 360 GA App 390.
I know that one.
And again, Your Honor, these all predate the new statute, and they all allude to the fact that there does need to be evidence to show your attorney's fees, which is fine, but we have that breakdown to show that we don't need a breakdown of the contingency fee, and that multiplier is clearly excluded under plain language of the new statute. They aren't introducing their written contingency fee agreement. They've conceded to that. The statute doesn't provide the specifics of a written versus just an understood agreement. These are all based on the fact that they have a contingency agreement.
Okay.
Can I briefly reply, Your Honor?
Yes.
And I just want to point out, we are not referencing the agreement between Scholl Law and Mr. Bennett. But the standard in the industry for these types of cases can be referenced with regard to what is reasonable for these types of cases. There's not going to be any testimony that this is the type of agreement that was entered into between Mr. Scholl and Mr. Bennett in this case. The only testimony is going to be that here's several ways to calculate a reasonable fee. A lot of times these cases are taken on risk, which can be taken on contingency, which can range from 1/3 to 40% to higher if on appeal. In this case, I'm calculating these fees based on the hours that have been, estimated, and based on the hourly rate that I think is appropriate, based on the experience of the attorneys involved. That's the testimony that's going to be put in. It's not going to be any reference to the actual agreement between Scholl Law and Mr. Bennett.
So, Your Honor,
respectfully, I would like to know what these multipliers are based on. The statute clearly states, if I can find my place, a contingent fee agreement between such party and such party's attorney shall not be admissible as proof of the reasonableness of the fees. So if we're trying to figure out what the reasonableness of those fees are, then what is their expert gonna get up and speak to? Well, correct, and the intention of the statute, as we've read through the legislative intent, is to get away from this multiplier of putting in millions and millions and millions of dollars, that the jury sees that for their award of attorney's fees. It's what was actually spent in this case, which we have that breakdown from plaintiff's counsel. We don't need this multiplier based on this contingency.
Right. So you'll have you'll have the hours, I'm pointing at plaintiff, y'all have the hours and expenses that y'all have put into the case compiled and ready to go. That's the exhibit. Your expert is going to be discussing what is basically reasonable and customary for these type of cases in this regional area?
Yes, sir.
Okay, I'm just trying to make certain I'm understanding what I'm about to hear. So,
What they provide us is a one-page summary. We don't see any billing type of invoice that you'd see kind of on the defense side that says 0.2 spent on this, 0.6, 1 hour. It's just full hours they estimate, hourly rate, and then the total. So we don't even have a way to explore the veracity of it.
other than cross-examination.
Exactly.
Okay.
And that one page also gives these multipliers with asterisks that allude to these cases that they brought up, stating how the contingency fee agreement is evidence of the reasonableness.
Okay.
So, and that's part of our motion, is to prevent them from putting that up because it's highly prejudicial based upon something the statute clearly intended to not allow.
And respectfully, Your Honor, the statute makes no reference to multipliers, nor does it say that no testimony shall be in about the industry standard or the normal type of contract, just the contract, the contingency fee agreement between the parties shall not be admissible. Not how does the industry normally calculate their fees.
Okay. And your expert is not going to utter the word contingency or anything in their testimony?
Nothing about the agreement itself. They're not going to say the word contingency. All they're going to say is that my understanding, and I'll try to make it as crystal clear with her as possible, is that these cases are sometimes taken on a percentage base, or are typically taken on a percentage basis, and there's a lot of risk involved, and that's why. But my calculations are based on the hourly rates.
Okay.
Which is a
All right. Anybody else need access to the record on this question before I take a minute and think about it?
No, Your Honor.
Okay. All right.
Your Honor, I would just caution allowing them to put up even the demonstrative that has the multipliers in it. It's so highly inflammatory.
I'm tracking. I mean, I'm tracking the question and I'm tracking the stakes. So I hear both sides. And again, this is this is still new territory for all of us. This is something we've all had several of these hearings on, but now we have all new rules for this as well. So, all right, y'all go ahead and get your notes ready for your openings. I'm going to give you a decision here real quick, but I've just got to sit here and stew on this for a minute. So we're at ease. We're off record.
15 minutes, Your Honor?
Okay, welcome back, everyone. Y'all may be seated. If you have your phones anywhere on you, go ahead and shut them off. We are still on track to potentially finish today, and so we're about to start moving through this next bit here. I have a little bit of last housekeeping as far as phase two goes before we pivot to fully into phase three. And so here is what we're going
Phase of the trial, we're seeking attorney's fees and costs on behalf of Mr. Bennett for this trial. Now, under Georgia law, if the defendants engage in certain types of conduct, wrongful conduct, then the plaintiff can seek his attorney's fees and costs for the litigation. And there's some specific language I want to go over with you. So under Georgia law, when there's intentional conduct of a defendant or a defendant recklessly.
May we approach?
You may. Okay. Members of the jury, at the end of this phase, I will charge you as to what the law is and to how you shall go about thinking of this. I'll tell you that what the jurors say to you is never evidence, nor is anything I say to you evidence. Mr. Scholl, you may continue.
Thank you, Your Honor. So under Georgia law, when there's intentional conduct or defendant recklessly disregards known harmful consequences more than mere negligence, the court can award, or a jury can award attorney's fees so that the person hurt doesn't have to pay them. And so we believe that the defendant engaged in such conduct. It's the type of conduct that was gone over in the phase 1 of the trial, talking about the chiropractic records, the certifications that were false, and the other conduct of the corporate defendant. So we're seeking Mr. Bennett's attorney's fees and costs. We're going to be very short. I think I'm going to take the stand to talk about our firm's expenses. And then we have an expert, Christy Childers. She's a very experienced truck attorney from Macon. And so we will get up and we will get down and we'll get this case to you. And I appreciate your time. Thank you.
All right. Ms. Fletcher?
Thank you, Your Honor. You all have decided what was involved in this case. You put it on the verdict form, phase 1. You found mere negligence. To talk about any other thing that's above that and later is irrelevant. You found that it was mere negligence. So when the judge is the one who charges you with the law, that is what you're going to consider, not what Mr. Scholl tells you. That's just lawyering. That's lawyer speak. Follow the law. And we all know this is double dipping. We all know what's going on here. And there's not the evidence to support any of this bad faith that the jury has to find to be able to award attorney's fees. So we would ask, give your due attention and, listen to the witness that gets up there, but understand what's really going on here. You found that it was mere negligence, and you've rendered a verdict of $7 million. This is merely just double dipping that the plaintiff's counsel is attempting with this third phase.
Objection, argument.
Members of the jury, I've just charged you that what the lawyers say is not evidence, and that I will charge you as to the law, and you will decide what the evidence is at the end of this case. All right.
I thank you for your time.
All right. Ms. Dabbs?
Nothing, Your Honor.
All right. Mr. Scholl, you may call your first witness.
Your Honor, plaintiff calls Mr. Scholl.
All right. Thank you, Mr. Myers.
Sorry. I'm amused by this a little bit. Are you not plugged in?
We undid it for your laptop. Let me just put them on.
Sorry, Your Honor.
Yeah.
Didn't
Oh.
realize we had unplugged. Not for me, for you. Oh. I'm sorry. She's the outlet I usually use.
Oh. I've certainly never created any technical issues in this courtroom, so can't relate.
Mr. Scholl, do you solemnly swear to tell the truth, the whole truth, nothing but the truth, under penalty of perjury?
I do.
Have a seat, please. How long have you been an attorney, Mr. Scholl?
30 years.
And how long representing clients in injury cases such as Mr. Bennett's?
30 years.
You've been doing that your entire career?
I have. I exclusively did personal injury starting in, 20 years ago. So I've been doing exclusively personal injury for about 20 years.
What about trucking cases involving trucking companies, tractor trailer collisions, things like that?
We handle a good number of those, probably about 30 or 40% of our cases.
Is there a significant difference in your experience between handling a trucking case versus a a normal car wreck?
Yes, so with trucking cases, because the vehicles are bigger, the injuries are usually worse. Because of the stakes involved with bigger injury cases, they're pursued more aggressively by insurance companies and by the trucking companies. So, there's just a lot more aggressive defense. And there's a lot of regulations. There's federal motor carrier safety regulations, there's the industry standards. So you have to navigate through that, and that usually requires experts. So there's just a lot more work in trucking cases.
Is there much risk involved in taking cases such as Mr. Bennett's?
Yes, so we don't, in a case like this, you have to expend a lot of money out in expenses. And if you don't recover, the attorney doesn't get paid. So there is a lot of risk.
Let's talk about the events of this case itself. You, in your opening, referenced some records. I believe it was Exhibit 27. Was that the Irish City Chiropractic records?
Yes, sir.
And what in those records did you identify as evidence of bad faith?
Objection, Your Honor, lack of foundation.
You can cross them on it.
Well, the records from Irish City Chiropractic were the certifications of the defendant, Mr. Evans. And for 5 years, we had records for 5 years. And what we did to get these records is we just sent subpoenas out generally across the central Georgia area. And we got hits for certain people, certain doctors. But because Mr. Evans had died, we didn't even have any information about his medical history. So we didn't get to take his deposition. We didn't get to do any discovery. So we just had to send out subpoenas to all the endocrinologists in this area. And then we got some hits. I think we were able to find out he was with the chiropractor. That's where he got certified. So we were able to subpoena those documents. And when we found those and when we looked at them, he had said that he either was not sure or he did not take insulin. And then we had hits from endocrinologists where it clearly indicated that he was treating with those endocrinologists and had been diagnosed as a type 1 diabetic. And he had been diagnosed as a type 1 diabetic 25 years prior to the accident. So type 1 diabetics are all on insulin, all take insulin.
Objection, Your Honor, lack of foundation. Mr. Scholl's an attorney, not an endocrinologist, not a medical examiner.
Right.
I mean, he's testifying.
He is. That is overruled as that is evidence that is in the record, and I'm not commenting on the strength of it. I'm just acknowledging that that's evidence in the record.
Thank you, Your Honor.
You may cross on it.
So for Mr., may I continue, Your Honor?
You may continue.
Okay. So from his records, from his own records, he admitted he was a type 1 diabetic and had been one for 25 years. That's how we determined that.
And your review of the records, I believe you said Irish City was those forms, and was it Kaiser, Permanente, and Jones City records that were with his actual endocrinologist?
Yes.
Okay. And it was in those records, I believe, that we heard Dr. Isaacs testify to
Yes.
the contents of those records?
True.
Now, as Mr. Fletcher pointed out in his opening, we're not just looking at negligence here. In your opinion, did the actions of Mr. Evans, how did those affect, in your opinion, public safety?
Objection, Your Honor, lack of foundation.
Overruled. You can cross on it.
Well, he had been educated on the dangers of driving. He had been educated by his endocrinologist. That's part of their standard of care. He had been educated on that for 25 years. So he knew the risks. He had acknowledged that he knew how to recognize the signs of high blood sugar, and that he knew the importance of compliance, and he just did not take his insulin. So he went to an endocrinologist. He told the endocrinologist that he wasn't a truck driver, and then he went to a chiropractor and said he was, but he wasn't on insulin. So that was just, we just found that was dishonest, and that's why it was a danger to public safety.
Your Honor, may we approach, please?
needs to move to the attorney's fees at this point. I felt like he could lay the foundation as to why he thinks there was bad faith, because that's the only topic that's here. He's not testifying that these things are accurate. He's testifying as to why he thinks these things support his attorney's fees. That's what I'm hearing.
That is correct. The way it's coming out is testifying as an expert.
Then I'll charge the jury that he's not testifying to the facts of this, but he's testifying as to the question of whether or not these things were sufficient for attorney's fees. Would that satisfy you? No. Okay. And your objection is noted. All right.
Thank you, Your Honor.
Hold on. Mr. Myers got something else.
I just want to make sure it's clear. The defendants moved to drop the Caden's trial because of the bad faith for attorney's fees in phase 3. Jury has not been presented with any question of bad faith for attorney's fees until phase 3 at the defendant's request. The plaintiffs did not request a trifurcation of this case, so argue that there's not being presented with a question that was reserved specifically by them in phase 3. Those things disingenuous.
You don't retry phase 1. That's what's making it happen here.
All right, members of the jury, this evidence from Mr. Scholl is not being presented to you for the truth of the matter asserted. This evidence is being presented to you in the question of whether or not, and I will charge you on what the law is, and you will be bound by that charge as to the definition of bad faith and whether or not that applies to the evidence. I just wanted to be very clear with you all that I'm not allowing this for the truth of the matter asserted, but as to where this testimony fits in the plaintiff's theory of their case for attorney's fees. And of course, Mr. Fletcher and Ms. Dabbs will be entitled to a thorough and sifting cross, which I will allow. All right, with that said, you may ask your next question.
Thank you, Your Honor. Did you include a claim for attorney's fees in your lawsuit filed on behalf of Mr. Bennett?
Yes.
And you specifically pled for those attorney's fees back in 2020, was it 2020?
2020 or 2021.
Under this code section, OCGA section 13611.
That's correct. And when we filed that, this was all in one trial. It wasn't broken out like this.
Was part of that claim also against the trucking company itself?
Yes.
Okay. And I don't want to get into too many conclusions here, but was that because you had interpreted, not that these are the facts, but had you had interpreted that their oversight constituted bad faith?
Yes.
Same objection, Your Honor.
Overruled.
Now let's move on to the actual hours your firm put in this case. How many hours, do you know how many hours your firm spent on this case, both yourself, attorneys, support staff? Do you have records of that?
We do. I don't know it by memory right now, but a lot.
Do you commonly keep those records?
Yes.
Like the actually hourly records?
Well, no, we don't usually keep them because we don't usually bill hours, but we do keep them on occasion on a case like this.
I'm just going to show you first. That's the one. You're on that.
You may approach.
Mr. Scholl, Mr. Scholl, can you review that, please?
Yes.
Now, do you recognize that document?
Yes, I do. This is the compiled time records from my staff in the work on this case.
And as the supervising attorney at Scholl Law, did the activities summarized with respect to each attorney and your support staff appear to be true and accurate?
Yeah, they look very reasonable. I mean, I didn't stand over everyone when they were doing the work, but I am there every day, and we don't allow telecommuting in our office, so I do supervise, not every single thing they do, but they look accurate based on my recollection and when I reviewed these.
And do the activities summarized with respect to what each attorney, the activities each attorney performed in this case, or your support staff, do those activities appear to be accurate as well?
Yes.
And in your experience as an attorney with significant trucking litigation work, is the amount of time spent on Mr. Bennett's case over the last 5 years consistent with what's required in this type of case?
Yes, it's hard work to do this case.
Your Honor, plaintiff would tender Move to admit into evidence Exhibit 145.
Objection. We object, Your Honor. May we approach?
So,
Thank you, Your Honor.
all right. You may continue.
Thank you. May we publish, Your Honor?
Oh, I needed to do, it's tendered and admitted over defense objection. And
you,
yes,
Your
you may publish. No, I'm moving to prosecution now. Oh, there it works.
And to be clear, Mr. Scholl, this document was prepared for this trial in this case.
Yes.
Can you go to, sorry, I don't have a copy for myself, giving my copies away. Can you tell us how many hours the attorneys in your office spent on this case? Or is that number not summarized on that document? Is it just summarized by individual?
I believe so. I mean, there's a total under trial hours on the last row, but it's not subtotal.
And what's the total for the trial hours? Is that, who's on that trial hour total?
Myself, you, and Mr. Stewart, who's another lawyer in our office.
And that's who was here with us for jury selection that first day?
That's correct.
And the total hours for trial just through, I believe, is that through yesterday's date?
Looks like 172.
Okay. And that's from Monday of last week through yesterday, correct?
That's correct.
Okay. Do you have any issue with any of the other numbers on that paper?
No, I don't. I've looked at them, and like I said, I wasn't standing over everyone when they did the hours, but I know generally what everyone's doing in the office and what they're doing on this case, and these will look accurate.
Okay, you can pull that down.
Objection, Your Honor.
Come on up.
Yeah.
Okay. Because I still feels okay. So y'all were answering yes to something?
Yes.
Okay.
Yes.
And that's just a miscommunication.
Yes, Your Honor. I
Perfect.
happened to look over.
I was, yeah,
Thank you, Your Honor.
Oh,
Sorry.
that's all right. All right, I'm just gonna say that one was on me. I thought that, I thought that I'd communicated well, but I did not. So, okay, then, anything as to, no, you haven't tendered that exhibit yet. What's that number?
78.
All right, 78, off you go.
Mr. Scholl, I just handed you what's been marked as Plaintiff's Exhibit 78. Do you recognize that document?
I do. These are the expenses incurred on this case.
Is it a summary of the expenses or is it the expenses themselves?
It's both. There's a cover sheet that is a summary of the expenses, and then the actual receipts or the invoices and statements are behind those.
Okay. And is that a true and accurate copy of the costs and expenses your firm has paid in litigating this case up through, I believe, June 12th of 2025?
Yes,
So prior to the start of this trial?
yes.
What's can you turn to the last page of this? Well, plaintiff would move to tender Exhibit 78 into evidence.
Objection?
No objection, Your Honor.
No objection, Your
All
Honor.
right, 78 is tendered and admitted without objection.
Mr. Scholl, can you turn to the last page of the summary? And let me pull up, I believe it's page 6. And what's the total amount of expenses incurred prior to the litigation of the case?
$143,024.76.
Does that include any of the experts that have had to come in and testify live at this trial? Well, what's the date that is good through?
Through 6/12, so it doesn't appear to, but, I think Dr. Isaacs is in here because we took his deposition. So, and Mr. Napier is in here, although I haven't gotten his final invoice. But I think it does include Dr. Isaacs.
Okay, so that should be a fairly up-to-date copy of your firm's expenses in this case.
Yes, up through the beginning of trial.
Okay. And are all these costs you incurred reasonable and customary in litigating a case such as Mr. Bennett's?
Yes.
No further questions this time, Your Honor.
Ross?
Mr. Scholl, feels odd to be calling you by your last name. How long have you been working on this case?
Sure.
So, Mr. Scholl, in terms of your hourly rate that you estimate for purposes of this case, that was at $800 an hour?
Yes, sir.
Okay, and you've heard throughout this trial, the judge complimenting us both on the great cases each of us have both tried. You've heard that along with me, right?
I appreciate it. Yeah.
Yeah, we both appreciate it.
Yeah.
And your rate at 800, and I'll tell you, my rate is 285 an hour. You don't think I'm a lesser attorney than you, do you?
Absolutely not. You're a great attorney.
Okay. And in terms of this Bennett compiled time records, when was this created?
It was created around the time that, probably 2 months, maybe a month or 2 months before we went to trial in this case.
Okay.
Yeah.
So this was not a record that you compiled contemporaneously with the time you worked on this matter, right?
No, we don't do that. We work on a contingency fee. Our cases are contingency fee.
Yes.
So-
So if your client wins, then you win. They don't owe you anything.
That's right. And
All right.
so we don't keep our hours, like, your firm keeps, you lawyers keep hours, but we don't keep hours unless, attorney's fees come to the fore in the case, yeah.
Yes. So your investment in time and effort is based upon hopefully getting a win for your client, right?
Yes.
Yes. Yeah. And then in terms of these estimates, like you said, because you don't do bills like we do, you don't have an itemized time of the 0.2 you spent or the 1 hour you spent. I mean, this is just an estimate, right?
Yeah, it's an estimate. Now, I will say that not all of them are estimates. We have Charles Cork in here. He does appeal and brief work for us. And he keeps his time records and kept all these hours like that. And Mr. Schugert and my hours were pretty close to the time they were incurred because we have Annette Molina in our office who's no longer with us, but she worked on this case for 4 years and she has the most hours. And then when it becomes close to litigation, Mr. Myers and I will get more involved. So
Yeah.
mine were closer to the time of the time of trial. So I know mine are really accurate, in that regard.
Yeah, but on the day of, say, one day in June 2023, you can't say specifically how many hours you spent in June 2023, right?
I don't keep hours like that because we're on contingency fee.
No, understood. So the jury just has to assume that what you're saying is accurate.
Well, I'm testifying to it.
Yeah, but you're
Yes.
just saying it's reasonable, right?
No,
You don't
I'm
have any document you can waive, like a trip sheet or a mileage log, that this is how much time I spent.
I'm saying it's accurate. I remember my hours. I remember the time I worked on the case. And we go back and we do keep document logs and we know when we prepared documents and we didn't look at that informing us on this.
Where are those document logs?
I'm testifying that I looked at those and that informed the completion of this document.
So, but for us to confirm that you actually put that amount of time, that would be in the document log, right?
Well, it's in the document log because that's how we look at it. That's how we create this timesheet.
Now, you talked about Annette Molina and Mr. Myers. They're associates, right? Are they junior partners?
Well, I don't know.
I don't wanna-
Sometimes, no.
I don't want to embarrass them. Sorry, I'll retract that.
I consider them partners.
100% approve. But they are billed at a less, or you estimate their time at a lesser rate, right?
Yes, and I'll point out too that, I'm the most experienced attorney, but when
30 years.
Yeah, but when we get when I say 800, I mean, we have overhead. I mean, that's all sort of baked into the cake there.
Okay, so that's baked in the cake. But in terms of what you estimated to be for the hourly rate for Mr. Myers and Ms. Milena was $600 an hour, right?
Mhm.
Yeah. Any reason you think that they are more qualified than Ms. Dabbs, who bills at $195 an hour?
I don't know what Ms. Dabbs bills at, but we bill at a higher rate because we have more risk. If we don't get paid, or, if we don't win the case, we don't get paid. So if you do hours, work hours, you get paid,
Exactly.
right, on
And,
every,
and you're getting paid because you won for Mr. Bennett.
right, but we could have lost,
Yeah, but you didn't.
right, but we didn't know that until today.
I know. So now that you've won, you're still seeking attorney's fees on top of that, aren't you?
I'm seeking attorney's fees for Mr. Bennett because he should not have to pay his attorney's fees out of his compensatory award.
These are just rhetorical questions. I think the jury, you already know this, but I have to ask it for the record. You're not a doctor.
I'm not a doctor.
You're not a medical examiner.
Nope.
You're not an expert in trucking regulations.
No.
No, you weren't in the conversations between the medical examiner and Mr. Evans as to what was shared and what knowledge was said, right?
I wasn't a part of that, but I know he didn't tell the truth because he was on insulin from his medical records and he says he wasn't.
That wasn't my question,
Okay.
Mr. Scholl. My question was, you don't know what exactly was said between the medical examiner and Mr. Evans.
I wasn't there.
Okay, and you're not an endocrinologist, right?
No.
And you're certainly not Mr. Evans, who's not here to testify about what he was thinking was what he was required to do, or he was just an ignorant person as to his medication, like some human beings are, right?
I don't believe that's true, but I wasn't there. I'm not characterizing
Exactly.
what his conversations were with his doctor.
And you would agree with me that the verdict form that you agreed and approved with us says, we, the jury, find the injury or injuries sustained by plaintiff were the result of negligence by one or more of the defendants. You approved that language in this, right?
I proved the language on phase one because that was the issue on phase one. And you moved the court to make it into 3 phases. And that's why the attorney's fees were left at this phase, the third phase.
I understand, and probably
Yeah.
now in hindsight, all the people in the defense bar were gonna regret the length of this. But in terms of what the jury found, you would agree with me, they found mere negligence.
Because they weren't asked that question, but that could have been in the first phase if you hadn't trifurcated the case so that this was a separate trial.
So you're now asking them to relitigate the liability phase to see if there's something worse than mere negligence.
No, I'm asking them to consider the evidence they've already heard and determine whether that was bad faith.
Mr. Scholl, I have no further questions because I think the jury's already found what they're going to found with respect to liability.
Ms. Dabbs?
I have no questions.
All right, Mr. Myers?
No, sir. Thank you.
All right, Mr. Scholl, you may return to your seat. You may call your next witness.
Your Honor, plaintiff called Christy Childers.
Ms. Childers out there, and I just want to put on the record that she was briefly in the courtroom because of a miscommunication on my end, and as soon as we realized that, I asked her to be escorted out. So I just wanted to apologize to counsel for that. That was 100% on me. You may come on around, ma'am.
Thank you, Your Honor.
Good afternoon, Ms. Childers. Can you introduce yourself to the jury? Oh, I'm sorry. Please raise your right hand. Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Under penalty of perjury?
Yes, I do.
Thank you. Can you please introduce yourself to the jury?
Yes, I'm Christy Crow Childers. I'm an attorney in Macon, Georgia, about an hour south of here.
How long have you been an attorney?
I've been an attorney for about 20 years, and I've been handling trucking cases for that long as well.
You're not one of Mr. Bennett's attorneys on this case, are you?
I am not. I've never seen him until today.
Can you describe your experience as an attorney, please?
Yes. So at 17, I got my own apartment and moved off to college, made good enough grades to get a full scholarship to law school, and then graduated first in my law school class. After that, I got the AV rating, which is the highest rating Martindale Hubbell gives for lawyers at age 33. I then became the first woman in Georgia board certified in truck accident law. That's what this pin means, the MBTA board certification. And I realized I was only one of the first 5 in the nation that were women. And that's when I decided to get more ladies into the cause of trucking and formed a group called the Mother Truckers. And we get together, and me and other ladies, we go driving tractor trailers all across the country. So I've driven tractor trailers too in both Montana and Alaska. I also teach. I teach at the advanced trucking seminars. I taught telematics, which is just basically a fancy word for saying all the things on a truck that talk back to the company. I taught on that at the advanced seminar, and I've also taught at both of the boot camps, which, because trucking is so specialized and involves thousands of regulations, we have to teach new lawyers, and a lot of times it's actually older lawyers too, just people who are just new to trucking, how to do what we do. And it's a 4-day thing. I've taught it a couple of times, and also hold CLEs all over the place myself and speak nationally on trucking topics more than my family would like for me to, because I'm gone a lot for that.
And can you talk a little bit about your experience with the laws, the regulations, the standards by which attorneys' fees are calculated?
Yes. So the Georgia Rules of Professional Conduct require me to consider a number of factors when determining whether or not a fee is reasonable. That's Georgia Rule of Professional Conduct 1.5. And in addition to that, there's a code section that the judge is going to tell you about. I'm not going to talk about that today, but it also talks about what's reasonable and what's reasonable under the law. Those factors include the time and labor required. And because of that, I went to Mr. Scholl's firm and talked to him and a lot of the lawyers there and paralegals and interviewed them myself. And then they gave us those hours that you saw previously in the case, and talked to them about what all was required, the novelty and difficulty of the questions involved, the skill requisite to perform their services, the likelihood that the acceptance of the particular employment will preclude other employment by the lawyer. That's another factor. And what that basically means is if they're spending all their time in this courtroom with y'all this week, then they're not working on anybody else's case. So they're not out there accepting other cases. And that's something that we have to consider if we're doing a big trucking case as opposed to like a smaller case that might take less time. You might could juggle a lot of cases at one time if you're handling something small, but something big like this, it's a shut down the firm situation. Number 3, the fee customarily charged in the locality for similar legal services. I'm in the locality. I'm in Macon, about an hour away. My law firm is Childers and McCain. My law partner has tried a case here before, David McCain. And in this area, the fee customarily charged is 40% of the total.
So before you go any further, have you previously testified with regard to the usual customary reasonableness of fees for litigation of trucking cases such as this?
Yes, I have. And not in a trifurcated trial. This is my first time testifying in a trifurcated trial, which is a more complex case. But the fee customarily charged...
Well, before we get there, just hold up
Yes,
one second. We would
sure.
just tender at this point, Your Honor, Ms. Childers is an expert in calculating the fees in trucking litigations cases.
No objection.
No objection, Your Honor.
All right, I will allow the testimony.
Thank you, Your Honor. Please continue with what I cut you off on. I'm
Sure, yep. So what is a contingency fee? You guys probably already know this, but like if my law partner and I take on a trucking case, we front the money no matter how many tens of thousands of dollars it takes to get the job done for the client. And that means we might not get paid. Because of that, our billing is a little bit different. And customarily, we don't keep records hour by hour, day by day. In a case like this, that's why it's important for me to go back and ask them to itemize, and they're allowed to give me general descriptions of the work performed. And that's what I required in this case, and every single person up there, even down to their head paralegal, gave me those descriptions. Now, the fee customarily charged, being a contingency fee, that does come out of the client's settlement if we're not in a situation like this where we're asking for attorney's fees. Now, The amount involved and the results obtained, that's one of the factors that I have to look at as well. Interestingly, the results obtained of your $7 million verdict align very closely to what their
Well,
hours
Ms.
came
Childs,
up with.
let me interrupt you there, because I don't want to cross any,
Hold on, Your Honor. Allow her to finish her testimony. I mean, he may be cutting her off on something we enjoy.
Your Honor, may I approach? Oh, all right, if he, yep, go ahead, Ms. Childers. I apologize for interrupting you.
Yep. So the amount involved, it involved a large amount. The the medical bills are a lot. It's a lot of time. It's a lot of work, and the results obtained, the $7 million, that's also a factor. The fifth factor is the time limitations imposed by the client or by the circumstances. I know from speaking to the paralegal that the client had a lot of medical needs and called the office very frequently. And so that was reflected in the billing as well. He had a lot of medical needs that the staff were involved with speaking to him about. So that was conveyed to me. The nature and length of the professional relationship with the client, if you got like a small case or like a misdemeanor case or something, you may only know your client for a little bit. Mr. Scholes has known this client for years and years and years, and that's why this is on the upper end of the spectrum as far as length of relationship with a client. And that's very typical for our trucking cases. I've got cases that have been going on 5, 6, 7 years, even longer. The experience, reputation, and ability of the lawyers performing the services. I did interview them on where they went to law school, how many years they've been in practice, and Mr. Scholl does have a reputation as a trucking lawyer, and he got hired by this client based on his reputation. Whether the fee is fixed or contingent is the last factor.
And, sorry, I apologize. I should not yawn in front of everybody. Exhibit 145 is one that we previously tendered. Is this the summary of hours that you reviewed?
Yes, and I see now that I've left out Mr. Cork's work on here. Mr. Cork, Charles Cork, he was paid differently. And so he was guaranteed his money. He was paid by the hour because he's an appellate lawyer that everybody in the state knows. And he got paid out of Mr. Scholl's firm's pocket $57,019.55. And so that's different from a contingency fee, which you're never guaranteed to get paid on.
And let me show you Exhibit 78. That's been tendered. This is the costs for shoal law.
Yes, I did look through this too. All right, so this is all of the expenses that they had in this case, and this is very typical, unfortunately, for one of our trucking cases. They're very, very expensive, and you've got to find a lawyer who's willing to write this kind of check and this many checks to pursue a case if we're going to continue to be able to pursue these types of cases on behalf of plaintiffs like the one here.
And so in addition to those items, did you physically go to shoal law? Did you review the files, the records in the database and that are at shoal law?
I did review the records, and I've got my notes of that here. It was all consistent with the same kind of work that we do on our trucking cases, but I will say that it was far more depositions than we typically take in a trucking trial. It was a lot of witnesses, a lot of documents. And I would expect this to be on the high range of work that has been required in a trucking case.
Mr. Childers, I'm going to hand you with our plaintiff's 146. Do you recognize that document?
I do. I prepared this summary after being given the total hours of the attorneys.
Your Honor, plaintiff would tender plaintiff's 146 to be admitted.
Objection.
We object. It's hearsay, Your Honor. Now, there's no exception to it.
Objections, Mr. Dabbs?
Same objection, Your Honor.
Okay. And who prepared this?
I did.
Ms.
Okay. All right, your objection's overruled. You may continue. It's tendered and admitted over defense objection.
And I guess I didn't ask that question. Did you prepare that yourself, Ms. Childers?
Yes, I did prepare this myself and inserted the trial hours yesterday and finalized it. So the trial hours are just through yesterday. They're not through today, but that's fine.
Okay, and this document, 146, I guess can you pull that up, please? Does that combine the hours that are summarized in Exhibit 145?
It does. So it has 6,390.5 hours pre-trial and 172 hours, trial hours combined after trial began. And I have the hourly rates there.
Well, before you get to
Yep.
that total number of hours and the hours worked by the attorneys and what you reviewed, is that consistent with what you would have expected to after reviewing all the records and file documents with regard to Mr. Bennett's case?
Yes, it is consistent with the massive amount of documents that I reviewed in this case that they have done. For example, they had 513 megabytes of discovery materials, 692 discovery documents in there. They had, in their medical subfolder, 299 megabytes, 244 separate documents. This was a huge file, and I would have expected that this is reasonable. The hours are reasonable, consistent with that large of a file.
How did you determine did you determine what a reasonable rate was for each of the attorneys involved in this case and the paralegals?
Yeah, well, yes. For the paralegals, I asked them what their rate was that they typically bill out at, if they do bill out. And the head paralegal, her name was Andrea, she told me that was $125, so I've got that on there for her. For Mr. Cork, the guy who billed by the hour, he had, at one point, his fee increased during the representation, which is normal every year, typically, or over time, your fee might go up. It was $315 for Mr. Cork, who was assured of payment at one point, and it went up to $350 an hour. This is going to be on the next page. Page 2. So it would be $315, and then it went up to $350. And so I've got that broken down to show his rate. Now, if we go back to the first page, Mr. Scholl, I have his rate at $800 an hour, which is my rate. He has been practicing law for 30 years. I've been practicing law for right at 20 years. I do have the specialty in trucking, but Mr. Scholl has the experience, and the law doesn't make any distinction between having the certification or the experience. Miss Annette Molina, we have her at $600 an hour, and she's been doing the same number of years as him. So you may be wondering, well, why have you got her lower? Well, she actually went and homeschooled her kids for many years. And so even though she's been licensed to practice law for 30 years, she took a break to raise her kids and do some other things. And she also worked at another type of law for a little bit of time before coming back and working for Mr. Scholl. So she told me about that when I visited with her.
Well, can I ask you, why am I so much cheaper than Mr. Scholl then?
Okay. Well, I don't think this is indicative of anything about you, Scott,
Okay.
but you have been practicing 19 years. And so I did talk to you about your background as well, and you came from the criminal side at one point doing work. That sounds kind of bad. He came from the criminal world rather than the civil world. And so a lot of his years of experience are in that. And so then I reduced him to 600, mainly based on your years, though.
Okay, and Mr. Shugart?
Same thing for Mr. Shugart. Originally, I looked it up, and it said he had less years than that, but Mr. Shugart actually came to us from another state. So he's been licensed to practice law for 24 years total, even though all of those haven't been in Georgia.
And after reviewing the hours, the experience of the attorneys, the work product in the file, did you come up with a total amount of fees that you determined to be reasonable under the standards you explained earlier?
So that's a couple of questions, I think, in one. From the standards that I explained earlier, the usual and customary fee in a case like this, where the result is $7 million, would be 40%, which would be 40%. got that at $2.8 million. So $7 million times 40%, $2.8 million would be what we typically would charge the client and have them pay us out of their fee in a case like this. Now, before you guys ever reached your verdict, I gave this to the lawyers yesterday, and that number that came up with looking at the hours and the amount of time, that came to $2.8945 million. That total that you see there, 2.894500. And so 2.8 would be what I would customarily charge in this area. The 40%, not just me, but that's reasonable customary. That would be the 2.8 million. And so they both came up to be very close.
But the amount that you're submitting as Exhibit 146 is based on the hours and the hourly rate that you calculated for the attorneys involved in this case.
Yep, that's what I have to do in this case. I have to give you the hours and the rate. And so the number that I'm submitting to you is 2.894500.
Now, does that number, that 2894500, include Mr. Cork's fee of $57,000?
Let's see. Charles Cork.
And I can give you quick math until you know it does not.
Okay. Yeah, I think you guys deleted perhaps may have deleted that line on here. So no, it does not, but I can get out my calculator and do the math. I had a line totaling it all up, and I think it might have gotten deleted by accident.
Your Honor, we'll stipulate to the math to move this along.
Okay.
We're not going to agree with it, but just the
Yes.
math formula, we're fine with.
That number does not include Mr. Cork's number. That's
It does
okay.
not, and I believe the number, based on my calculator, is 2,951,519.55.
And I'm just going to put on the record that without consenting to that number being accurate, they are consenting that that would be the number on the document, correct?
I'm just consenting to whatever the math is. I just don't want to quibble over it at this point.
That's all right. And I was just trying to make certain you didn't waive your objection.
Thank you, Your Honor.
Thank you, Your Honor. And did you determine the total fees and costs on Exhibit 146 to be usual, customary, and reasonable in this matter?
Yes, the expense, let me give you that number, was $143,000. $143,024.76. 143,024,024.76.
Don't think I have any more questions at this time, Ms. Childers. Thank you.
Okay.
Ross?
Yes, Your Honor. Ms. Childers, I'll be very quick. You testified earlier that for cases like this, the plaintiff's attorney takes on some sort of risk, right?
We do. Yes,
Yeah.
sir.
And then if their client recovers an award, the attorney then gets paid from that.
Yes, it comes out of the client's share of the recovery, and it is, goes into our trust account. However, we don't always get the full fee. Sometimes there's other people with their hands out to get paid. And as an attorney, I have a duty to make sure that all competing interests are satisfied.
Yeah, but the attorney's then rewarded for that risk because they got a recovery for their client, right?
If we win, we are. Unfortunately, there are cases where that isn't the case, and so that's why we take on these cases so that hopefully it evens out to where the cases that we don't win and the cases that we win.
But you're not aware of anything that's keeping Mr. Scholl and his firm from being rewarded from that risk for having won for their client? You're not aware of anything that's going to prevent them to get paid from their recovery for their win, right?
Are you asking me whether or not I know whether or not there's something that could make them not get their full amount in this
Yes.
case?
Are you aware of anything that doesn't get them their full recovery under their agreement with Mr. Bennett?
Your Honor, may I ask a question outside the presence of the jury, outside the hearing of the jury?
Do you understand my question?
I do understand your question. I'm afraid that my answer might not be something that the judge wants me to say.
You've got it on cross.
Yep, Your Honor, I do.
There,
But you just testified that in some circumstances, there are things that limit what the attorney who's borne the risk recovers.
mm-hmm.
You're not aware of anything in this case, are you, that limits what anybody can recover?
There are things, and I would expect there to be in this case too, that could limit the amount that the attorneys actually do recover.
Yeah, but
typically the attorneys do recover from the verdicts they achieve, right?
No.
No, they don't typically recover.
I would
So
say-
they worked for free.
The amount that is rendered in a jury verdict is not always recovered by the attorneys. That is not always consistent, although I would imagine people probably think that's the case. Just because you get a big verdict doesn't mean you're going to get paid.
I have no further questions, Your Honor.
Stats,
No questions, Your Honor.
redirect.
No, Your Honor.
All right, may she be released?
Yes.
Yes, sir.
All right, you may be released, ma'am. You may stay or go as you please.
Thank you. All right.
Thank you. All right, Mr. Scholl, Mr. Myers, y'all may call your next witness.
Thank you.
Plaintiff rest, Your Honor.
All right. Any witnesses from the defense?
None for transcontinental, Your Honor.
All right, let's take a 15-minute.
None, Your Honor.
Oh, I'm so sorry. You stood up and said, golly, it's almost like we've been at this 2 weeks. I'm sorry, Ms. Dabbs. All right, well then, give me just 1 second, ma'am, before you go anywhere. All right, then, let's take a 15-minute break, let them get their notes together, we'll do closing, and get y'all this case. All right, so if y'all will step out, don't do anything I've previously told you not to do.
see what she. You don't understand the electronics down.
There it is.
I can figure it out.
Maybe they.
Did I hook it back up?
Yeah, there you go. There we go.
You got it.
Hello, Mr. Myers. We are, just making sure whether it's. All right, let's see. Let's go. All right, hold on. I talked to Scott Myers, who's uses upstairs, I guess, working on a slide.
Okay.
She gets an eight. She gets an eight. She can read it.
No apologies. We're all just trying to wrap it up. We're good.
Lewis is out in the hallway. He's in the corner by the master. Oh, you're fine.
You just speeding. Don't get you
What's that?
He says you're fast.
I am tired.
Yes,
I know you are.
we're all in this together. All right, you ready to go back on record? Okay. So just a reminder, there were continuing witness objections to all three exhibits, I believe, that were just put in. Is that correct, Mr. Fletcher?
Repeat that again, sorry.
I said, in phase three, we had I'll do it more detailed. In phase three, we had plaintiffs 78, 145, and 146. And I believe they were all admitted with a continuing witness objection with it, or am I making that up?
Yeah, I'm so tired.
Okay.
I
Yeah.
believe so, but can I look at them
Yes.
again?
Yeah, I'm
I'm
just
so
saying,
tired.
I believe you're correct on that these three don't go out. So I'm saying I believe Mr. Fletcher is correct that these three should not go out with the jury. So I just want to make certain I say that so that if anyone wants to reference them or point them out, do it in your closing. Because the jury will not,
Which one, I don't think 78 is a continuing.
Yeah.
Okay,
no,
that's-
it's
That
not.
goes out.
that's,
That one
okay.
goes out, yeah.
This is why I'm having this conversation, because I was like,
145 and 146, we states continuing testimony.
okay. So, and they'll have 78 with them in the jury room, but 145 and 146 will not. Did I get that right?
Let me just talk to Mr. Myers. Should put hours.
Your Honor, I would say the hour summary was not read into the record. It was just summarized briefly as to, I don't even think it was actually summarized even, just that it was an accurate restatement of the hours spent. I don't believe anything was read from the hour summary at all.
Well, and unfortunately, I think my earlier ruling on the, we are all really tired. I think my earlier ruling where I said that it had been read in pieces but not the whole may not have been exactly tacking one side to the correct side of that question. So, so I'm course correcting on this one and saying it was testified to, it was put up on the screen. And so the continuing witness objection is confirmed. And so 145 and 146 can be waved around, shown to the jury, put up, ask them to write specific things down, but they will not have it with them during their deliberations. They will have 78.
Thank you, Your Honor.
Well, I understand. What was that, Clement?
78 goes out, 145 and 146 doesn't. Oh. Sorry, I just caught that joke.
Put it on the
Okay.
record. Can we put that on the record?
Yes.
Inaudible mumble, mouth full.
What do y'all say? Indiscernible due to crackers in the mouth or something? I don't know. I'm sorry.
How many pages?
This one is 16, but frankly, they've already heard 11 of the 16. So I've got to get some more clarity on whether I have to read the same things over and over again. You what? Yes. So sorry. Okay, members of the jury, just to make certain we've done this all correctly, y'all, plaintiff is rested, correct?
Yes, Your Honor.
And y'all have no witnesses and y'all have rested.
No witnesses, and we've rested on behalf of Transcontinental.
Same here.
All right, then, which means there's no rebuttal, which means these jury charges get shorter and shorter, but that doesn't make them short, and I know that, and I'm sorry. So I'm going to read these to y'all again. You're going to hear some quick closing arguments, and then y'all are going to have this case, and there's no tricks here. This is the final phase. Once y'all have rendered this verdict, your service will be concluded. So phase 3, regarding attorney's fees and expenses of litigation. Final charge to the jury. Members of the jury, you have heard the case of Lewis Bennett as plaintiff versus Eugene Dabbs as administrator of the estate of James J. Evans, Transcontinental Carriers Incorporated, Occidental Fire and Casualty Company of North Carolina's defendants, State Court, Spalding County, case 20 SV 302. The plaintiff has filed this action here in the State Court of Spalding County, and the parties will outline their contentions to you in their closing arguments. These are the instructions as to the law that you shall apply to the facts of this case as you find them to be, and a copy of this charge, which is phase 3, will be given to you to have with you in the jury room during your deliberations. Instructions for phase 3. As I stated in my preliminary instructions, Georgia General Assembly recently enacted several changes as to how these civil trials are conducted. One such change is that I'm now required to present this case to you in multiple phases. We've completed phases 1 regarding fault and phase 2 regarding damages. This is the third and final phase of the trial where you have heard evidence related to the question of attorney's fees. As I previously stated in previous phases, you must consider this as a lawsuit between people of equal worth and equal standing in the community and between people holding the same or similar positions in life. All people stand equal before the law, and all people are to be dealt with as equals in the court of justice. Business entities such as Transcontinental Carriers Incorporated and Occidental Fire and Casualty Company of North Carolina are to be regarded as people in this instance. The plaintiff must prove every essential claim, part of the claims, by preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. A preponderance of the evidence means the amount of evidence that is enough to persuade you that the plaintiff's claim is more likely true than not true. In deciding whether any fact has been proved by preponderance of the evidence, you may consider the testimony of all the witnesses, regardless of who may have called them, all the exhibits received in evidence, regardless of who may produce them. And if the proof fails to establish any essential part of the plaintiff's claim by preponderance of the evidence, you must find for the defendants as to that claim. Under our legal system, it is my duty as the trial judge to determine the law applicable to this case. It is your duty as the jury to determine the facts of the case, and it is your duty to apply the law to the facts in reaching your verdict. Evidence is how any fact that is put into question is established or disproved. Evidence includes all of the testimony of the witnesses as well as the exhibits admitted during the trial. Evidence may be direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. Direct evidence is the testimony of a person who asserts that they have actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is a proof of set of acts that tend to prove or disprove another by inference. There is no legal difference in the weight you may give to either direct or circumstantial evidence. A different way to explain direct and circumstantial evidence is that direct evidence is the testimony of a witness who has seen or heard the facts to which the witness has testified, and that, if believed, is sufficient to prove or establish these facts. Circumstantial evidence is the testimony of a witness who has seen or heard a set of facts to which the witness testifies, from which such set of facts, if believed, you may find that other facts to exist, if such other facts are reasonable and believable to you in light of your experience. When circumstantial evidence is relied upon to establish a fact, it must reasonably establish that other fact rather than anything else. Members of the jury, you must determine the credibility of the witnesses. In deciding this, you may consider all facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. To impeach a witness is to show that the witness is unworthy of belief. The credibility of a witness may be impeached by disproving the facts about which they testified. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter, but that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely on the opinion. Attorney's fees and expense of litigation. Members of the jury, attorney's fees and reasonable expenses of litigation are not generally allowed as part of the damages. However, if you determine by a preponderance of the evidence that the defendant has acted or the defendants have acted in bad faith, then you may award attorney's fees and other reasonable expenses of litigation. Acted in bad faith. In finding that a defendant's bad faith shall only be based upon the defendant's conduct that gave rise to the underlying transaction out of which this case arose. Conduct in the underlying transaction that will support a claim for acting in bad faith in a tort action requires conduct that is generally indicative of intentional wrongdoing or a reckless disregard of known harmful consequences and must be more than mere negligence. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence, according to the law given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, do not be influenced by sympathy or prejudice for or against either party because of race, creed, color, religion, national origin, sexual preference, local or remote resident, or economic status. Additionally, do not decide this case based on any implicit biases. Everyone, including me, has feelings, assumptions, fears, perceptions, and stereotypes. These are known as implicit biases, which we may not even be aware of having. These hidden thoughts can impact what we see and hear, how we remember what we saw and heard, and how we make important decisions. You're making very important decisions in this case, and you should resist jumping to conclusions based on personal likes, dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, biases. The law demands that you return a verdict based solely on the evidence in these instructions. In issuing your verdict for Phase 3, you shall use the verdict form provided to you by the court. if you believe from a preponderance of the evidence that the plaintiff should be awarded attorney's fees, then you would find for the plaintiff, and the form of your verdict would be, we, the jury, award attorney's fees and expenses of litigation to plaintiff in the following amount. And then you would fill in the blanks provided on the lines with the amount of attorney's fees and reasonable expenses of litigation that you believe are reasonable. However, if you do not believe by preponderance of the evidence that the plaintiff should be awarded attorney's fees and reasonable expenses of litigation, then you would find for the defendant, and the form of your verdict would be to enter $0 on the amounts on each of these two lines. Once you've completed the verdict according to these instructions, you have completed the responsibilities in phase 3, which is the final phase, attorney's fees and expenses of litigation, and you should notify the bailiff that you've reached a verdict for this final phase of this trial. The court has no interest in the outcome. As I've stated repeatedly throughout this trial, but I'm saying it again, nothing the court has did or said during this trial was intended to hint or suggest to you which of the parties should prevail in this case. Whichever of the parties is entitled to a verdict is a matter entirely for you to determine, and whatever your verdict, it must be agreed upon by all of you. The court's interest in this matter is that the case be tried fairly, presented to you according to the law, and that you, as honest, conscientious, and impartial jurors, considering this case as the court has instructed you, and return a verdict that speaks the truth as you find the truth of the case to be. During your deliberations, you must not communicate with anyone other than the fellow jurors by any means at any time about this case. You must not use electronic devices regarding this case. You must not access the internet in any manner regarding this case, and you must not conduct any research whatsoever until after I accept your verdict. Whatever your verdict is in this case, it must be agreed to by all the jurors. It must be in writing. Please use ink, not pencil. It must be dated and signed by your foreperson. It must be returned and read out loud in the court. As usual, I will personally read your verdict aloud in open court. Your verdict must be unanimous. One of your first, you've already elected a foreperson. You should start your deliberations with an open mind. You should carefully consider all the evidence and deliberate with an aim towards reaching a unanimous verdict consistent with your consciences and oaths as jurors. Avoid premature fixed opinions. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of this case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should never surrender an honest conviction or opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. At this time, the plaintiff and defendants may each choose to make a closing argument. During closing argument, the attorneys will point out certain evidence and law that they consider favorable to their position and will argue persuasively for you to decide the case in their favor. All parties may choose to make a closing argument. Again, the closing arguments are not evidence. As previously stated, Georgia law provides that the plaintiff may choose to present closing argument before, after, or both of the defense argument. Mr. Scholl, what's your preference?
Your Honor, we'll reserve the second closing as well.
All right, so
So
you'll
we'll do both.
you'll do both. Okay, so both. So
Sorry.
same order as always. Mr. Myers, are you going to be presenting the closing argument for this?
Mr. Schroll might do the last cleanup, but
Okay.
just,
All right, so it'll be, I'll just tell the jury. So it'll just be plaintiff, and then Mr. Fletcher, and then Ms. Dabbs, and then the closing by the plaintiff. All right, well then, that's it for me. Plaintiff, you may present your first closing.
thank you. Can you share the white screen?
Yes. There we go.
Thank you.
Okay.
Good afternoon, ladies and gentlemen. You've heard it 1,000 times. Thank you again. If I'm more than 10 minutes, please yell. Same standard that you've looked at the entire time of this trial is preponderance of the evidence. It's still that 51 over 40 that you're looking at. Now, what's changed in this phase of the trial? Is it like Mr. Fletcher stated in his opening that we're asking you to relitigate negligence? No. This is a completely different portion of the trial. It's the third phase for a reason under the legislature. They don't think it fits with negligence. They don't think it fits with damages. They think they want you to account for it separately. Go to the next slide. And so that next separate thing is called, have they acted in bad faith? I don't know. we can look at it and say common sense. We're not talking common sense at this point. We're talking the legal definition of bad faith. You might say, yes, they acted in bad faith because my gut says so. That's not what I'm asking you to look at. I'm asking you to look at the actual, next slide. Definition of that bad faith that the judge is going to ask you to read in that jury instruction. What is the definition of bad faith? It requires conduct that's generally indicative of intentional wrongdoing or a reckless disregard of known harmful consequences. More than negligence. I'm not asking you to look at negligence. I'm asking you to look at, did they act in legal bad faith? Are you going to look at the evidence in phase one? You're not going to have them back in the room with you, but you remember them. You remember what Mr. Evans did on his driver certification. Was that intentional? Did he intentionally lie to his certification examiner to get his CDL? Did the company recklessly disregard the risks of putting him on the road? That's what we believe happened. Not going to belabor them. You know what happened. You've seen the evidence. You've heard the testimony. You've heard from Mr. Ogletree. You've heard how he hasn't changed a thing about this. Reckless disregard for known harmful consequences. Nothing's changed. So what are we asking for in this case? We're asking for you to look at what Ms. Childers reviewed. She reviewed all of our files. We got an outside attorney to look at our files. Did you guys do what I expect to see in one of these cases? Yeah. I looked at your records. I looked at your actual files, and I went through them. Did those records match up with what I expect on the time records? Yeah. And then she created a summary, and she said, how much is that time worth? I charge $800 an hour. Mr. Scholl's been an attorney doing this longer than me. I might have another certification he doesn't, but he's been doing the same exact work for longer than me, so yeah, I'm going to let him charge the same thing. Someone like myself who was a prosecutor for 15 years, yeah, I don't expect to get charged at $800 an hour like somebody that's been doing trucking litigation for 30 years. But I've tried 1,000 cases in Fulton and DeKalb County. They're just misdemeanors. They're just crimes. So I'm at $600 an hour. Does that mean our $2.95 million in fees as calculated on an hourly basis are not accurate? I don't see how there was, because there's no other evidence in this case to suggest that they're not reasonable. There's nobody that got on the stand and said, nah, that's out of whack. You're charging too much. Mr. Fletcher tried to argue that, well, I only get paid $215 an hour. He gets paid for every 6 minutes that he works. He bills 0.1 for every 6 minutes. And he gets paid for all of that time. Plaintiffs don't operate that way. Plaintiffs' attorneys don't operate that way. We only collect if we succeed on behalf of our clients. If we came in here and lost this week, 5 years' work, not a dime. Now here's the problem here. It's being portrayed as us, Shoal Law, double dipping. Mr. Bennett is paying the fee for our work in this case. He is the one who is paying our fee out of the $7 million that you all felt compensated him for his injuries and his future harms, his future pain and suffering, his future medical bills. You compensated him to that amount because you believe that's what he deserved. Now he has to pay us out of that fee. What we're asking you to do, because of the bad faith of the defendants, is to have them pay our fee. Because Georgia law allows that for exactly this reason. So we're asking you to pay on attorney's fees $2.95 million. The numbers I think Ms. Childers said was just a little bit over that number, but I'm not good at repeating the company. I'm not going to sit through any of that. For costs, we were saying just over $143,000. We're just asking for a flat fee on that. So our total amount that we're asking for Mr. Bennett to pay is $3,093,000. I think it's broken down on the verdict form differently. Can you pull that up? So you're going to get this verdict form back there, and we're going to ask you to fill in those same numbers. Under attorney's fees, $2.95 million. Under expenses of litigation, $143,000. This is not Shoal Law getting paid by Mr. Bennett and then getting paid by TCI and Mr. Evans' estate. This is Shoal Law getting paid by the defendants for the work they did on behalf of Mr. Bennett to allow his compensatory damages to stay with him. I ask you to Remember that when you're going back to deliberate, consider it, and if you think that's fair, and you think they breached the duty that Georgia put into the statutes of bad faith, that they intentionally committed wrongdoing, that they recklessly disregarded the safety of the community and how they acted, by the evidence you've seen over the last 2 weeks, then we ask you to award attorney's fees on behalf of Mr. Bennett. Thank you.
Mr. Fletcher?
Yes, Your Honor. Thank you, everyone. I'm going to be very, very brief. We can turn on camera.
Yes.
Okay.
Yeah, sorry, I had Margaret move it, but it should, you got it.
Bingo, looks like I need to get my nails cut. You already ruled. You found that my clients were negligent. We respect that. You entered a significant verdict of $7 million. While we disagreed, you guys, we respect it. You did it. And because of that significant amount that you awarded Mr. Bennett, we know that you factored in those facts that plaintiffs are arguing about egregious conduct, of intentional conduct. We don't think that took place, and we thought we presented a case that said otherwise. But you guys, by entering a verdict for $7 million, already addressed it. We don't need to relitigate it. We ask that you enter for attorney's fees, 0, expenses of litigation, 0, and let us all get out of here. The plaintiff's got the award that he was entitled, that you awarded him. Plaintiff's counsel will be paid for that award. This matter is done. So we ask that you fill this out for 0. Thank you for your time.
Ms. Dabbs? All right. Final close?
Your Honor, thank you, ladies and gentlemen. I got nothing else. Appreciate it.
All right. Thank you, Margaret. All right, so a couple of final housekeeping before y'all have the last decision on the last phase of this trial. You're about to go into the jury room, and here's the housekeeping. As you'll remember, there's a bailiff outside the jury room that will be here during your deliberations. If you have any questions, have your foreperson write the question out, sign it, date it, fold it in half, and pass it out to the bailiff. The bailiff will bring your question to me while you continue your deliberations. I will respond in writing, or I will bring you out into the courtroom to address your question. Once you have a verdict, you'll follow the same procedure as the questions, except your foreperson keeps the verdict. Your foreperson and you all will come out into the open court. I'll ask your foreperson some questions, and then I will read your verdict out. Before you begin your deliberations, make certain you turn your phones off again, pass them to the bailiffs. Again, you're in charge of our schedule. I've already covered that. Do not begin your deliberations in this phase until I have delivered these items to you. I will remind you again that you will receive the exhibits from phase 3. If you decide you wish to have any of the exhibits from phase 2 or phase 1, you may request them specifically, and they'll be brought in to you if you have them. You'll have this verdict form, and you'll have these instructions. Alternate, same instructions. If y'all will go grab your items, come back into the jury box, and I'll give y'all further instructions from there. You all may retreat to the jury room at this time to begin your deliberations. All right, to my alternate jurors, do you all wish to stay? Obviously, this will be the last decision, and you're heavily invested. Okay, then I'm gonna let y'all grab a seat out in the hallway where you were. Just stick out there for a minute. They can keep their phones. And Margaret, here's the jury charges and the verdict form. No, it's just one exhibit. It's 78. They'll find it. They'll hand you 78. All right, so for record purposes, Margaret has 78, the jury charges, and the verdict form. Does anybody else want to look at that before she takes it out?
No.
Everybody's good. And the two alternates are sitting out in the hallway, which means our jury can start deliberating as soon as Margaret's finished. Any exceptions to the charge from the plaintiff?
No, Your Honor.
Defense?
Yeah, yeah.
No, Your Honor.
All right, any housekeeping before we go off record?
No, Your
Oh,
Honor.
hold on.
I don't think so. If they take very long at all, I'll be shocked.
Yeah.
It's either money or penalty.
Um, What we're gonna do is, when Margaret comes back out, I'm just gonna confirm with her that everything else has been brought back out. I'm pretty sure it has been, but we'll wait and see. Before we go off record.
No, Your Honor.
Okay. I keep saying it, but I just can't say it enough. I am very, very grateful that my very first trial with these new phases was with y'all. I appreciate y'all's effort. I appreciate your professionalism. I frankly appreciate y'all's communication lines between each other, even when you don't agree. So I don't know. One of y'all at the end of this will go to the Court of Appeals and tell them what a crappy job I did, and one of y'all will say what a great job I did. But whichever one of you it is, I'm very grateful to have all of you in the courtroom doing this with us. So
And I want to say on the plaintiff's behalf, we appreciate your hospitality, we appreciate your professionalism. You
so let's go on record then. The jurors have not, you said they had a verdict. Is that correct, Mark?
That's correct.
All right, any housekeeping from the plaintiff?
No, Your Honor.
Anything from the defense?
No, Your Honor.
No, Your Honor.
Okay, all right, same process as always. I'm not gonna walk through it again. If y'all, I'll make certain to ask if y'all have anything else before I release the jury, and if you want to poll, that's your opportunity. Other than that, I will say that the parties, Mr. Bennett would love to speak with y'all a quick minute out in the hallway, but that won't be in here. Oh, I do this all the time. This is,
Let them go home.
yeah, this isn't special for you. I always tell them that if they want to stick around, because there's usually one or two that want to stick around. I mean, they feel connected to everybody. They want to talk to
sure.
everybody. Okay, Margaret, if you'll let the alternates and the jurors in, we're ready to roll. Oh, okay, that's even better. Yeah. I think we got everybody. All right, y'all may go see. All right, so, again, as we're all learning this new system, Mr. Stewart, if you'll rise again, I can see you holding the verdict in your hand. Have you all reached a verdict?
Yes, sir.
Was it unanimous?
Yes, sir.
Have you reduced that verdict to writing on the form that I've given you?
Yes, sir.
You've used ink, not pencil.
Yes, sir.
All right, if you'll pass it over to Margaret, I'll take a look at it. If it's in proper form, and you may have a seat. Okay, it is in proper form. It says, "We, the jury, award attorney's fees and expenses of litigation to the plaintiff in the following amounts: attorney's fees, $1,546,500, 0 cents. Expenses of litigation, 0. This is our unanimous verdict this 26th day of June, 2025. Y'all can take a look at it.
That's all.
Thank you, Your Honor.
All right, any objection to the form of the verdict from the plaintiff?
No, Your Honor.
Defense?
No, Your Honor.
No, Your Honor.
Okay, all right, then I'm going to pass this down to the clerk, and this will officially be the verdict of the, anything else before I release the jury?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right, that concludes your service. Everyone, thank you. Again, y'all have been so patient with us. This, Margaret's passing out your phones again. Couple of parting things. I've been chirping at y'all for 2 weeks now. Don't talk about anything. Don't talk with anybody. Don't tell anybody what's going on. All of that is officially over. You've given me your last verdict, so you're released from your oath. It's very normal for the parties and their attorneys to want to reach out to you and talk to them. Feel free to talk to them. Feel free not to talk to them. It's completely your decision what you do next. I will tell you though that you may want to stick outside in the hallway, just outside of the elevators for a minute, because Debbie actually has y'all's checks ready to roll to give to you before you leave. I know it's only $25 a day, but it is nowhere good enough to compensate y'all for the sacrifices y'all have made, as well as frankly the sacrifices other folks have made for y'all to be here. So I just want to say again, thank you for your patience. Thank you for your service. Y'all have been a phenomenal jury. You've been on time, you've been attentive, and if there's anything I can do for y'all at all at any point, please let us know. Those juror badges that you have are yours to keep. It's just a little memento. Again, not nearly as valuable as your service, but just there's only one rule with the badge: don't wear it back into the courtroom after today. So, because that would be super awkward. Does anyone need anything from the court, or do y'all have any questions that we can answer?
Just the letters.
Yes, so Debbie's gonna meet y'all out in the hallway and she'll take care of that. And again, if the attorneys or their parties reach out to speak with you, you're welcome to talk to them, you're welcome not to talk to them. I just wanna make sure you know that is a very normal part of the process. When I was in private practice, I always reached out to the jurors that just said, what'd you think? And so that's completely up to you. If you do not have any other questions, I'm going to say thank you and I'm gonna cut y'all loose. All right, that's it. Thank you very much. Thank you. Anything else from the plan?
No, Your
Defense, anything else? Anything else? Nope, nope, nope. This matter is adjourned.